Hi friends, in this class of Indian polity, we will discuss like Indian constitution has been framed or formed by taking out various aspects from different constitutions of the world. Like Indian constitution, Indian constitution is called as Indian constitution is called as a borrowing bag. Is called as a borrowing bag. Now, why Indian constitution is called as a borrowing bag is a very important question. The answer to this is we have our constitutional makers, the people who were there in the constituent assembly has referred to various constitutions across the globe before taking out various provisions from different constitutions across the globe and putting that provisions into Indian constitutions. That is why the Constitution of India is called as the borrowing bag. Now, the answer to all the critics who says that we have taken various aspects, we have copied the various aspects, the answer to them is we are agreeing to the fact that we have taken various aspects, but each aspect has been molded or given an Indian flavor according to the need of Indian society or according to the demand of the Indian society. So even after taking various aspects, every aspect has been reconsidered and molded as per the need of our society. So there are various aspects taken from different places. We need to know from where the provisions has been taken. See, the first place from where the provisions has been taken is Government of India Act 1935. This act was made in year 1935. So what has been taken from Government of India Act 1935? Administrative structure of center and state. Friends, you know India has a center government. At present stage, we have BJP who is ruling, NDA who is ruling at the center. So we have a center government. Each state has one state government. So how does the state and center government function? How does the center and states administrative structure function? This has been taken from the Government of India Act 1935. The first provision has been taken from Government of India Act 1935. The second provision which has been taken from Government of India Act 1935 is Office of Governor. Each state of India has a governor, and governor is also called as the head of the state. It is not CM the head of the state, it is the governor who is the head of the state. The office of the governor for each state, even for the union territories we have the governor, this office, the post of governor has been taken from Government of India Act 1935. Now the third provisions, idea of federalism. Now when we talk about the word federalism or federation, when we hear this word, it just means center state relationship. What does it mean? It means center state relationship. Now what is center state relationship? We have a center and we have various state government. State government 1, state government 2. Each state and center maintains a relation or they work in a cohesive manner. This is called center state relationship or federalism. The idea of federalism is taken from Government of India Act 1935. The next thing, emergency provisions. When a particular state or a union territory fails to function as per the norms of the constitution, emergency is put on there. That is put down by the central government, but the provisions of the emergency, how the emergency will be implemented, the provisions of the emergency has been taken from Government of India Act 1935. The fourth point is emergency provision. It has been taken out from Government of India Act 1935. I hope this much is clear. And the fifth point which has been taken from Government of India Act 1935 is the Honorable Supreme Court of India or the Supreme Judiciary. The Supreme Court has been taken from Government of India Act 1935. So 5 things has been taken from Government of India Act 1935. Administrative structure of center and state, Office of Governor, idea of federalism, emergency provisions, and Supreme Court of India. Administrative structure of center and state, Office of Governor, idea of federalism, emergency provisions, and Supreme Court. All these provisions were taken from Government of India Act 1935. Now, let us move to United States of America. What has been taken from the United States of America's Constitution? Preamble. The first page of the Constitution, Preamble, or it can also be termed as the introductory page of the Constitution, or the preamble of Indian Constitution, gives a bird eye view of the Indian Constitution. It is so precise that it gives a bird eye view of the entire Constitution. The preamble has been taken from United States of America. So the preamble has been taken from United States of America. This doesn't mean that it has been copied from the Constitution of United States of America. It only means that the idea of the preamble has been taken from the Constitution of America. Fundamental rights. There has been certain rights which has been given to the citizens of India. All those rights which are mentioned in Part 3 of Indian Constitution. Part 3 of Indian Constitution are termed as fundamental rights. Later on we will be studying the fundamental rights in a very detailed manner, but those rights which has been mentioned in Part 3 of Indian Constitution are fundamental rights, and this fundamental rights has been taken from Constitution of United States of America. The third thing which has been taken from United States of America's Constitution is equal protection of law. The law will protect each individual equally. That means even the Prime Minister is equal in the eyes of law. Every citizen, irrespective of caste, color, place of birth, sex, that every individual is equal before law. So equal protection of law is also taken from the Constitution of United States of America. The fourth point which has been taken from the Constitution of United States of America is independence of judiciary. No individual or no authority has the right to indulge in judicial aspect. No one is given the authority to enter into judiciary. Judiciary is an independent authority. No one has any right to interfere into its own matters, judiciary's matters. So independence of judiciary has also been taken from the Constitution of United States of America. The fifth point is judicial review. What is a judicial review? See, firstly, when we talk about the concept of judicial review, I would like to point out the concept of judicial review is not mentioned in the Constitution of United States of America, but it is practiced in the United States of America. This concept of judicial review has been taken from America and inculcated into the Constitution of India. See, I'll explain the concept of judicial review a little bit. Lok Sabha and Rajya Sabha makes a law. They have to make this law by passing the bill. Once the bill is passed, it goes to the President of India, and once the President of India gives his assent to the bill, that means he signs the bill becomes an act. Lok Sabha or Rajya Sabha passes a bill. Once the bill is passed by the Lok Sabha or Rajya Sabha, it directly goes to the Honorable President of India. If the President of India gives his assent to the bill, that means he signs the bill, then the bill is stated to be passed. That means bill becomes an act. And if in case the Honorable Supreme Court of India feels that the act is not in accordance with Constitution of India, that means this act which has been made by the legislature of India is not in accordance with Indian Constitution. This act is not in accordance with Indian Constitution, then the Supreme Court can order for judicial review. That means they will review this entire act. And if it is found that this act is not in accordance with the Constitution, then they will declare this act as null and void. Null and void means this act will not be relevant anymore. I will repeat once again. Lok Sabha and Rajya Sabha passes a bill. Then if the bill is passed by or given his assent by the Honorable President of India, the bill becomes an act. After the bill becomes an act, if the Supreme Court of India finds that, after ordering judicial review, they will examine this act, and if the Supreme Court of India finds that the bill is not in accordance with the constitution, or the act made is not in accordance with the constitution, then the act will be termed as null and void. That means the act will not be existing anymore. This is the process of judicial review. Now, the last point is vice president is the chairman of Rajya Sabha. We have also taken this concept from the Constitution of United States of America, because in United States of America, the upper house, like in India, the upper house is Rajya Sabha. In United States of America, the upper house is Senate. And the chairman of their Senate is their vice president. In US, the chairman of their Senate is vice president. Similarly, in India, the chairman of upper house, that is Rajya Sabha, is vice president. That means the chairman of the upper house is vice president of India, whereas the chairman of upper house in United States of America as the vice president. This was all about United States of America, what we have taken or adhered from the Constitution of United States of America and put into the Constitution of India. I repeat: fundamental rights, preamble, equal protection of laws, independence of judiciary, judicial review, and the post of vice president, that who will assign also as the role of chairman of Rajya Sabha, was taken from United States of America. Preamble: fundamental rights, equal protection of law, independence of judiciary, judicial review, vice president, the chairman of Rajya Sabha or the upper house. This was taken from United States of America's Constitution. Now, what has been taken from the Constitution of United Kingdom or Britain? The concept of parliamentary form of government. Parliamentary form of government just means that we will have two houses, that is Rajya Sabha and Lok Sabha. United Kingdom also has two houses. This concept was taken from the Constitution of United States of America. So we have parliamentary form of government, that is Lok Sabha and Rajya Sabha. This concept was taken from the Constitution of United Kingdom's Constitution, that is Britain's Constitution. Next thing, single citizenship. The concept of single citizenship, that the entire India will only have one citizenship. Like in case of US, like in case of America, we have dual citizenship. The citizens of America are given the citizenship of the country. That means like they will have citizenship, US citizenship, as well as they will hold the citizenship of their native states, like California citizenship, New York citizenship, Washington DC citizenship. But in case of India, we will only have single citizenship. And adding to that, an Indian citizen cannot hold citizenship of any other country. So in part 2 of Indian Constitution, while moving forward, we will know how Indian citizenship can be adhered or how Indian citizenship can be lost. So an Indian citizen cannot hold the citizenship of any other country also. In case if he has citizenship of any other country, then his citizenship will be cancelled. Rule of law. We have taken this concept also from the United Kingdom's Constitution. Rule of law, that means law is above all. No authority is above law. Law is above all. The fourth concept that has been taken from the Constitution of Britain is Office of CAG. What is CAG? Comptroller and Auditor General. He deals with the financial aspects of the nation. We will deal with the post of CAG in detail in coming classes. And the final point is writ. Now I won't tell you writ in detail because I have to explain you the writ in the detail in coming classes. Writ is just a supreme command or a command of court. This also, there are five writs we have to study, like habeas corpus, mandamus, quo warranto, writ of prohibition and certiorari. We will analyze this writ in detail, but this writ, the concept of writ, has been taken from Constitution of Britain. Office of CAG also was taken from Constitution of Britain. Rule of law was taken from Constitution of Britain. Single citizenship was taken from Constitution of Britain. And the parliamentary form of government was also taken from Constitution of Britain. Now, what has been taken from the Constitution of Ireland? Directive principles of state policy. We can also call this as DPSP. DPSP lies in Part 4 of Indian Constitution. Part 4 of Indian Constitution, DPSP, Directive Principle of State Policy. This has been taken from the Constitution of Ireland. And the concept of president's election. President's election as how the president of India will be elected. The election process was also taken from the Constitution of Ireland. Now, what has been taken from Canada's constitution? Federation with strong center. Earlier also I discussed the term federation or federalism. That means a center state relationship. See, we have various number of states in our country, but center is the key aspect. Center all holds the states. Like center is the one of the most powerful authority. That means center, we have a relation between center and state government, but center will have more powers, or we have a central government which is much stronger than the state government. So Canada's constitution gave us the provisions that center will be more powerful than the state government. And we also took the residuary powers from the Canada's constitution. What is residuary powers? See, in our country, the list of the subject are divided into three. The first, in the constitution schedule 7, there are three lists mentioned. One is union list, number 2 is state list, number 3 is concurrent list. Now what is union list? Some items, some like army, navy, air force, this directly comes under union government. So this all are the aspects that has been covered in union list. Some items comes under state list, like state police. This comes under only in union subject, only union government or central government can make laws, whereas in state subjects, state government can make laws. There are some subjects in which state government can make laws. In concurrent list, some items lies in state under the parameter of state government as well as union government. That means in the subject which are in concurrent list, both state government and union government both can make laws. That means both the government, union government as well as the state government, can make laws on the subject that lies in the concurrent list. So there is union list in which the central government can make laws. The subject which lies in union list, central government can make law. The subject which lies in state list, the state government can make law, and the subject which lies in concurrent list, both can make laws, union government as well as state government. But the matter that I need to discuss is not this. The subject which lies in the concurrent list is like if union government has also made a law and state government has also made a law, and the law is colliding or there is a conflict between the law which is made by the union government as well as the state government, the union government's law will preside over the state government's law. That means union government's law will take into consideration. But this was all the aspects that were put in the schedule 7. But what are residuary powers? Some items like when we launched Chandrayaan, this was earlier not in union list or state list or concurrent list. The missions of ISRO, some aspects are which are taking place right now are not there mentioned in any of union list, state list or concurrent list. Where these matters which are being held taking place now, where it will be put into, this will be put into residuary list. Residuary means extra. So those aspects would be put into residuary list. Who will make the law on the residuary list? It is the central government who will make the law on the residuary list. Okay, the central government will make the law on the residuary list. Now, what has been taken from the Constitution of Germany? See, we discussed that emergency provision was taken from Government of India Act 1935, but the emergency provisions lies with central government, that only central government can implement the emergency. This concept, emergency provision was taken from Government of India Act 1935. That is very much clear. But who will implement this emergency? It is the central government who will be implementing the emergency. This concept of central government implementing the emergency provisions was taken from the Constitution of Germany. And also the suspension of fundamental rights during emergency, that these fundamental rights won't work during the time of emergency, or the fundamental rights can be suspended during emergency, was also taken out from the German constitution. Now, what has been taken from the Constitution of Australia? See, cooperative federalism. I earlier told you that wherever the word federalism or federation comes, it is center-state relationship. Cooperative federalism means center and state both will work in a cohesive manner for the progress of the nation, or center and state will work together for enhancement of the economy or welfare of the nation. This is the concept of cooperative federalism, and the concept of cooperative federalism was taken from the Constitution of Australia. And here in the Schedule 7, I discussed three lists: union list, state list, and concurrent list. The concept of concurrent list was also taken from the Constitution of Australia. See, in this class, I have discussed various places from where the provisions were taken and put into or drafted into Indian Constitution. We have discussed what has been taken out from Government of India Act 1935. We have discussed what has been taken out from United States of America's Constitution, Britain's Constitution, Ireland's Constitution, Canada, Germany, and Australia's Constitution. I hope the topics is much clearer with you. Thank you.